Thank you all for joining us on what I know is a very busy day for you all, lots to see. So we're Mishcon de Reya. We are a full-service law firm for the world of business based in Holborn, just up the road. For the next 45 minutes or so, we're going to share some of the experience that we've gained from working with the Leap 100 companies over the last couple of years. There's more information about the Leap in the bags on your seats, but essentially they are 100 of the most exciting fast growth companies in the UK. And we convene those over the course of a year to run a series of events, connecting them both to their peer group so that they can learn, connecting them to funding from VCs, and also to the best in professional advice, both in the shape of ourselves and also in other legal services. I'm joined today by partners from across the firm, Sally Britton, a partner in our IP team. Hello, Sally. Lewis Cohen, who's a partner in our commercial contracts team. Sam Perkins, an associate in corporate. And Susanna Kintish, who joins us on special assignment from maternity leave from our employment team. As Mark said, there's time for questions at the end, so do get your thinking caps on. Sally, can I start with you? You specialize very much in the areas of IP and brand protection. What sort of advice do you have for someone who's just starting out their new business?
Working? Yeah. Okay, so one of the exciting aspects of starting a new business is actually choosing your name, and this is something that trips up a lot of the clients that we work with. So, as you may or may not know, IP rights need to be considered on a territory-by-territory basis. So actually, it being okay in the UK, if you're a business that might be operating in a number of jurisdictions, might not be enough. So whether or not you're talking to someone like me, who specialises in that kind of thing, what you should do is just go on Google, use online tools like TMView, do some searches, and do those searches before you fall in love with the name, before you talk to other people about the name, before you spend lots of money on branding, and all the cool, fun and interesting stuff, because actually you may spend more time trying to be able to use the name and more effort behind that, more money on people like me, and when you should be spending time marketing. And also you might have to place limits on your business to be able to use that name. So as you know, your business might be very dynamic, it might move into lots of areas you didn't even expect. Having to limit yourself away from an area, I mean, the classic one is the big dispute between Apple, the music company, the Beatles company, and Apple, the computer company. Now, they entered into a series of very expensive and lengthy disputes around who could use Apple, because at an initial stage, actually, the computer company was okay to say, I don't want to use it for music, but the world changed. So I guess what I would say is really think carefully about the name and do investigations. But the other thing is that I do trademark and design protection. That's kind of what I do. But that's not the only thing you need to think about. Actually, going neatly on to Lewis, who will speak to you in a second, who kind of focus on commercial contracts, a lot of aspects of your brand will be able to be protected automatically, for example, in relation to copyright, by having the right commercial agreements in place. So it's not just about registering a trademark. There's other things you can do as well, which you might be doing already.
And you've had live experience, I think, with some of your clients about non-traditional trademarks that you can enforce.
Yeah, I've had live experience, not only as a kind of an advisor of clients who are trying to get things through, for example, colour marks or shape marks or things like that. I mean, typically, actually, your name is probably going to be the most important thing for you to protect, because that will be the core that will be used on websites and branding, etc. So we usually say focus on protecting that first. I also have personal experience from, I used to be a brand manager before as a lawyer. I worked at a large brewing, like multinational brewing company, and I was the person that spent tens of thousands of pounds on positioning research, marketing, advertising, all these kind of things, when I hadn't even talked to someone on seeing whether I could use it. And that actually is not a great conversation to have to a business.
Right. Lewis, you deal with firms who are more in the scale-up rather than the start-up mode. Have you got any advice for people who find themselves at that stage?
Hello? Yeah, I do. I will just like to pick up on something that Sally's been talking about. So Sally's been talking about the importance of picking a brand. And as you mentioned, I come at it from the commercial perspective. Often, actually, when businesses are looking to get investment and someone's then poring over their books and saying, well, what kind of shape is this business in that they're asking me to give them 100,000, 500,000, 5 million pounds? Is this something I can invest in? And so they come to someone like myself who's an expert in commercial contracts, particularly those with an IP angle to them. And they say, look, Lewis, what do you reckon about this company? And we work closely with our colleagues in the corporate department. And so often, actually, we find that the businesses haven't got their IP rights in order. And it seems very basic, it seems very obvious, but they haven't worked out necessarily, and sometimes they're very IP-rich businesses, and the first thing they've done is file patents. So obviously, they're very focused on the IP. But when it's less obvious, when it's either software or which is protected by copyright, it's amazing how often we're analysing businesses and either there's no agreement between the founders or people were working on it before they set up the company when they were previously employed by other people who could argue that actually, well, I own that underlying source code or some of it because you developed that whilst I was paying you money and that was your job to do when you were with me. They haven't written agreements between them which say who owns what. They've used friends or family or people overseas and they're their mates or they were their mates 3 years ago, but there was no written agreement which you need to have in place to transfer copyright. There has to be a written agreement signed by the person who created the rights. And if someone is an employee of your business, they might then it's not owned automatically by your business. Or if you haven't even established the business when they've done it, then they'll own it. And so sometimes we're looking at businesses and actually they haven't identified all of their valuable intellectual property rights. They haven't worked out who owns them. They haven't done enough work to make sure that that business actually owns their rights. So those are integral first, second, or third steps. And that really feeds into what Adam really asked me, which is when we're looking at businesses and helping them to grow. So the first thing we have to do to them is say is, well, what do you have that you can lend, either use yourself or lend to other businesses to grow internationally because you want to use other people's revenue, for example, through a licensing or a franchising or some other model. And so that's always the starting point, be it for investment or a growth. And my tips really there are, okay, check what you've got, and then think about who are you partnering with, what experience have they got. It seems obvious, but it's amazing how many people are blown away by this very exciting person who's approached them saying, we want the rights to the Middle East, we've got loads of money, we're going to do this, that, and the other. And they don't stop to say, well, is that true? What's your experience? Who's going to be the team working on this on the ground? What's your capability for growing it in this region? Have you done this before? What access to the market you have? Basic commercial questions often go out the window because there's an ego or there's a flattery or there's a desire to get to market as fast as possible. So we're often required to actually test our clients and say, well, hang on a minute, don't give these people exclusivity over there because you're then locked out the market yourself and there's no targets on them. So it's all about thinking at these from well, if you're giving people rights, give them a target. If they don't achieve something by a certain date, you can get that market back or get that rights back. So particularly if you're giving exclusivity or even because that blocks you in a market, even if you're giving someone non-exclusive rights, that still blocks you from giving someone else exclusive rights. So we often see people who, particularly early on, give away rights or give away opportunities which they don't think are core and live to regret it as their businesses grows or scales up.
I guess what we're saying, and we would say this, wouldn't we, that we understand that when you're in startup mode, you're moving at 1 million miles an hour and going and seeing the lawyers might not be the top of your list of priorities. But what you don't want to be is penny wise and pound foolish and end up regretting it later on in the day. Yeah,
the only thing I would add, I know my colleagues want to speak, is that there's tension. You know, no one has loads of money, particularly in early stages of a business. And, you know, no one wants to have a business where you've had the best contracts in the world, but you've spent all your money on legal fees. So there's always that balance, and you've got to be pragmatic. So it's just getting good advice early on about what are the core things you need to worry about every time, and then having that as your principle, and as you get more money, scaling up the quality of the advice you're getting and the amount you use it, I think.
Fantastic. Thanks very much. Sam, turning to you, I know that you do a lot of work with firms in the tech sector. What have you observed as you've worked with these people over the years?
So what I often see time and time again are startup tech companies or fast-growing tech companies where they're approaching the time where they need proper finance to get off the ground, whether that's bank finance or more commonly equity finance. And at Mishcon, we often act on both sides of the fence, both for the investee companies and either the lenders or the investors. And what often happens is we're shown the kind of contracts and company books and all the information that the company has, and there are often quite large holes in that information. And then if we're acting for the investee company, then what we often have to do is kind of fill in those holes and try and present a very attractive package to the investor. Or if we're acting for the investor, we need to kind of due diligence the company and get to the bottom of exactly what the company's got, what it owns, what it doesn't own, what employees it has, what employees it doesn't have, what Lewis and Sally were talking about the IP, who owns it, what is it registered, etc. I think really the take-home message and building on what Lewis was saying is that I can't overemphasize the importance of just being organized and kind of keeping proper records of what you've been doing. You know, keep copies of all the contracts you sign, and you don't need to spend thousands of pounds on legal fees to achieve this. I mean, this is stuff that businesses can do in the early period, kind of themselves. Just make sure that, you know, if you're going to talk to a potential customer or supplier and your business is very confidential, then, you know, get them to sign a confidentiality agreement. Again, you don't necessarily need to spend thousands of pounds on a law firm to draft that for you. You know, you can get documents like that available online. But the importance of, particularly when you come to want finance, to be able to show your potential investor that you're serious, you mean business, you've thought about potential issues that might face your business, and that you've got solutions, or that you can show the investor, no, don't worry about that. This is a full-time employee. I've got an employment contract with them. The IP that they've been generating does sit within the business. It just gives that kind of comfort that you're ready legally where you are to match the kind of the story that you're telling. So that's the first bit. And the second bit that really applies to entrepreneurs and the actual stakeholders in startups is to think about the arrangements you have with your fellow shareholders and founders. It can be quite a difficult conversation to have early on, particularly if you're bootstrapping it, if you're already employed somewhere else and you're kind of doing something on the side. But have that conversation early on. Who owns what? How long are you going to be in the business together for? What happens if one person wants to leave? Who's contributing what? What does that mean? Those are the kind of difficult conversations. It's much better to have up front and to document them than to have an argument when serious money is involved later on.
That's great, thanks. Do you find that that young companies are sometimes put off from going to see law firms? They're intimidated, or it goes to the bottom of the pile? What do your clients tell you?
I think there's definitely an understandable focus on startups to want to just crack on with the business and start growing the business, and that money spent on things like accountants and lawyers is maybe not the best use of capital. But equally, I have seen instances where the kind of lack of foresight or organisation in that respect can actually be a real hindrance when it comes to seeking finance. So it's a sensible balancing act, and it doesn't mean that you have to go and see a lawyer and then commit there and then to paying them £5,000. You know, you can have an introductory conversation where lawyers often won't actually charge, and if you sit down for an hour and talk about what you're trying to achieve and where your business is, then at least at the end of that conversation you should get an idea of whether it's worth your time and money in kind of getting further
and as much strategic advice as contract advice, I guess.
Correct.
Fantastic, thank you very much. Susanna, turning to you for a sec. So moving from startup mode and being being a one-man band, as it were, to actually being an employer and having responsibility for employees is a critical stage for any company. So how can companies get this right?
I think the starting point is maybe slightly earlier than that, and it's maybe mapping out your vision of what your workforce looks like. Is it having full-time employees? Is it having part-time employees? Is it having fixed-term workers? Is it using an agency? All of these things, they all have their advantages, they all have their disadvantages, but it's really important for you to think about the ethos of your business. You know, I'm sure you'll have a 1, a 3, and a 5-year plan of where you want to go, but just having an early thought about, you know, not everyone has to, it's quite an old-fashioned way to have full-time, you know, employees. There is a flexibility that you can have. So I think that's the starting point. Think about what you need and why you need it. And obviously you'll have to revisit that as your business grows. But thinking frequently about the type of people you want and the type of people you want to attract is really important. Once you've decided on the nature of the, I'll just call them employees for the sake of ease, but they might not be employees, the type of people that you want to attract, you then need to have a process for attracting them. And I often, startups often, and in fact all businesses, this isn't a startup specific problem, run into issues quite early on when it comes to the recruitment process. The smaller the business, the less formal the process. It's often a chat over a coffee. You could be having 20 chats, 30 chats with people, and it's often the touch and the feel that is right for your business, and there's nothing that you can really put your finger on. But actually just having a bit of a process where you can go back and say, codify that touch and feel, and those codifications obviously need to be as objective as possible and non-discriminatory, because applicants for jobs do have rights if they feel that they've been discriminated against in a selection process. So just to sort of cover yourselves, you know, I've had clients who have been sued actually by applicants because they say they didn't get the job because they were older, or they, you know, especially tech companies, they tend to use like young and savvy and things like that, and that's will obviously necessarily exclude certain parts of the population. So just think about those things, and when you come back from your coffees, just try and assess people against as an objective criteria as possible. Once you're through there and you've decided what type of people you want, you've gone through the process, the next thing is contracting it and doing it properly. So if you are going for employees, it's a legal requirement that they have a contract. They absolutely have to have one. It's got to have certain things written in it. If you're going through agencies, think about your terms with them. Key things to think about for a contract: notice periods. You know, how do you want them? Do you want the same period that you have to give the employee and the same period back? Do you want employees at all levels to be on the same notice period? So if there was a sort of team move scenario, if everyone hands in their resignation on one day, they all finish on the same day? Or is it better to have staggered notice periods? Think about garden leave provisions. Do you want the ability to exclude someone from the workplace because this person's critical and they've got access to all of your information? Think about confidentiality. How are you defining what is confidential to your business, and how are you saying that employees need to deal with that information? The law is quite strict on confidentiality, and if you don't protect it yourselves, the law isn't going to step in and do your job for you as business owners. They want to see that you've defined what is critical to your business and that you've got protections in place for that. When people leave, can they go and join your competitor day one? Can they go and speak to clients? Can they go and speak to suppliers? Have a think about all of these things. And those specific provisions need to be very carefully drafted in order for them to be enforceable. IP is also critical, especially as Lewis just touched on. If you're not using employees, if you're using self-employed contractors, and they're whatever they're doing for you, coding at home, where does that IP sit? You really need to think about that and have a contract with them that says that that's yours, so that you can then use that and build on it in the future.
That's great. I guess you've covered what I'm about to ask you anyway,
Right.
but it's worth asking the question anyway. We all know that a lot of legal documents are now available online, fairly
Yeah.
standard things.
Yeah.
Could you just say a couple of words about the pitfalls maybe of going down that route?
Look, I mean, I think, you know, as Sam was saying, if you're on a kind of real kind of shoestring budget, you can get the things that you have to have in an employment contract. they're called Section 1 particulars. You can get those off the internet. They're bog standard. I'm not sure a lawyer could add very much value in tinkering with them. As long as you're commercially minded, you know what you need to say, just say it in plain English. The things that really need thought are your strategic questions, so things like your notice periods, just thinking through how an exit would look, how a team might leave, how do you want to structure the contracts overall so that you're in a sort of least risk possible. Restrictive covenants are really critical because the starting point is that they're not enforceable and they have to be drafted really well in order to make them enforceable. So just if you have the same set of restrictions for every single employee, from your CEO to your new coder that started, you can basically tear them up and throw them out the window because they're not going to work. You have to think really carefully about the duration of them and what you're stopping people doing, because I mean, it makes sense if you're essentially stopping people potentially from earning a living. You have to be very, very specific in what you say they can't do, and it has to be backed up by a very, very sort of imperative business need. Why could it be so damaging to your business if this guy leaves and goes tomorrow to join a competitor? And using post-termination restrictions in tandem with things like notice periods and garden leave to really give your business the most protection when someone critical leaves. And just going back to the funding question, if you're going to funders and they say, upload your contracts to a data room, and actually your CEO hasn't signed the contract, and they think, you're saying you've pitched to us on the basis that this guy's critical, he could walk out tomorrow and go and join, your biggest competitor. That is a fundamental, that would be like a red flag on any DD report that we wrote. So just thinking about things, not only should you get contracts, but all of your post-termination restrictions will not be enforceable unless those are signed.
Brilliant. Thank you very much. Now, as Mark mentioned, we did have some questions emailed in, and I'm hoping that the individuals are in the room. Otherwise, I'm going to have to ask the questions, and I don't even understand some of them. So I'll give it a go. So do we have Georg? Georg in the room? Oh, Georg. Would you like to ask us your question about mezzanine and convertible loan funding rounds? Or would you like me to ask it?
Yeah, thank you for giving me the opportunity to ask the question. So as an entrepreneur, you usually start off with typical equity, and then in the later stages you go to maybe debt rounds. So my question would be, if you were an early startup entrepreneur, would you also start off with a mixed financing or with some more, let's say, innovative but more complex deal structures?
And I guess Sam may be best placed to answer that one.
Yeah, good question. My strong preference is to keep things as simple as possible, both because I think it's a more attractive proposition for investors, and also I think it will be cheaper, both in terms of kind of legal fees and kind of your time in structuring that, and also making sure it works properly. I mean, everyone kind of really understands equity. You pay money, you get your shares, you own a share in the company. Slightly more exotic instruments like convertible debt, more difficult to draft, more difficult to get right. And then in future funding rounds, they need to, that needs to be dealt with. Either the new investors need to invest knowing that that's kind of sitting there, they're going to need to understand it, how does that impact their rights? And also it impacts on certain kinds of tax relief. So EIS, Enterprise Investment Scheme, is a very attractive tax relief that the individuals who are investing in startups can get. That's not available for convertible on convertible loans. That's only available on straight equity. Same with SEIS, which is for earlier stage seed rounds. So it really depends on the context. Your business, how much you're trying to seek, who you're trying to get the money from. So there's no kind of right answer. But if equity alone would do it, then if you're a startup, that would be my advice. The only caveat to that is, go into it with your eyes fully open. How much money you're getting and how much equity you're giving away, and are you happy to live with that?
Right, thank you. Hope that was helpful, Gail. And I'm going to make apologies in advance for mangling any names. I do apologize. Olga Nechaeva. Hello, Olga. Olga, you had a question about expanding the brand.
Hi. In my startup, I'm basically building a brand, and I'm currently facing a dilemma on whether go through licensing and stay strong on the brand, and which obviously limits your ability to expand fast, or whether allow for sort of broader potential number of distributors or licensees to come in, which may potentially dilute the brand and the brand proposition. And I just was interested to hear different opinions on that.
Lewis, this is right up your Strasse.
Hello. Hi, Olga. Very interesting question, very commercial driven as well. So I guess you talk about you're building a brand, so some of it really links into what Sally was saying before as to actually to what extent have you checked that your brand can travel internationally? Have you got protection for that brand in overseas markets? I don't know what your business does and what I'm assuming it's product-based if you're talking about distributors and agents, but also in international markets, there's different laws in relation to distributors and agents. So in the UK and the rest of Europe, when you terminate an agent, they get a payoff which is equivalent to the commission they've earned, well, at least in the last year. But in the UK, it's actually the value of their agency business, which could be very substantial if they've helped you to grow the business. The truth is very much similar to what Sam says. It does depend very much on your business, because a distributor, you have more control over a licensee than you might do with an agent, but over an agent than you might do a licensee. But the reality is, it depends on the quality of the agent, the distributor, and the licensee, the strength of your brand, the strength of the product that underlines the brand. So it may well be actually that you have that you try that you utilize all three. It depends again on how much time you've got to commit to managing them. But a lot of the time, it's how good is the quality of the potential partner. So if you have, with an agent, then you're only really going to give them the ability to solicit customers, potentially to negotiate and market to them. You're still going to have to contract with the customers they find. You're still going to have to manage that relationship. With a distributor, you really want to have a distributor who knows their market, who's got fantastic contacts at a retail level, who's going to open the doors. And with a licensee, again, it's about, do they know, have they done this for either competing or complementary brands? What access do they have to retail? How quickly can they get your product to market, manufacture to the quality that you expect, use the brand? So the truth is, it's not a one size fits all. It does depend on really how your business is structured, whether you're in a position to fulfill all the market yourself, and so you could go down an agent and distributor route. But if actually you're going to need other people to help you to grow internationally, then licensing can be beneficial. So it may well be you have licensing in certain territories which are out of your reach, or where you don't have the capital to support it in those territories. You don't have the infrastructure. There's different complicated legal issues. You couldn't necessarily import or export to those territories. So I think you have to look at. It's not necessarily I'm just going to use agents. We sometimes see, particularly with early stage businesses, that they start with some agents. They then want to get rid of the agents, and they get a shock that they have to pay the agent a horrible termination fee. They then might have distributors, and the distributors aren't interested in their brand. Promise a lot, deliver nothing, and again, it goes down to the contract. How good are they going? What promises are they going to make, and have you articulated them in a contract? You sign up with the wrong licensee. So it's all about finding the right partner as well. I'm very happy to have a chat with you afterwards.
So it sounds like one to discuss over a sandwich after the
so.
session. And because you've still got the mic, Olga, you had a second question, which I think Sally might be able to help with, around the scale of marketing investment required. I can read it for you if you like.
No, I've got, it's just like I had so many questions. Right, yeah, that's like more of a founder's dilemma. So let's say by the way, it's a property business and it's a property brand, so it's not a product, and therefore we're talking mainly about licensees, just that, I clarify. So again, let's say I'm looking in expansion, and for me, realizing in order to attract more licensees, in order to structure licensing proposition, bring in people with money, I need to invest in marketing, and means that I probably need to put together a strong, big marketing campaign with, solid budget behind that, and invest in, let's say, a strong marketing lead to put together a coherent plan. Now, so far, I've been doing it myself on a pretty much bootstrap level. And I'm struggling to make a decision whether I should just decide to put another chunk of money, build the marketing campaign, and then sort of reap the rewards, or whether I should continue bootstrap and add a little bit by little bit with just the money which is, coming through pure revenues. I guess that's a dilemma question rather than a specific one.
Is that one for you or me?
I think it might be one for you, actually.
I used to work for advertising agencies before I did this. I think you're right. There is no simple answer to this, and it is horses for courses. You will know more about your objectives and your target audience than we can talk about. But what I would say is that it's remarkable what you can achieve on quite a low spend these days through PR and through social media. And I don't think you need to default to spending huge amounts of budget. Equally, if you go to the people who own these properties, they'll do a lot of the market planning for you. Don't think that you need to have a professional marketeer in your team managing it all for you. You can always scale later. Anything to add to that one?
I guess the other thing I would say, having advised a number of people in the sector and a number of startups, is that in terms of your expenditure, take it stage by stage. And I guess I am going back to my original point in saying, choose the name and clear it to the extent that you can. There are online tools. I mentioned this TMView before, which searches a number of international databases, can look at registered trademarks and big issues. Google, think about your industry. So, right now I'm dealing with, I can think of one client I'm dealing with who's created some amazing branding, and it includes logos and straplines and all kinds of things, all framed around this name. And this name they can't use. So now they're in a situation of unpicking everything. So make sure you you don't overspend, and actually potentially have to redo the entire thing. Yeah.
The final pre-prepared question was from Betty. Betty in the audience? Betty didn't make it. I'm going to read out Betty's question anyway because it's really good. Betty says, I'm interested in tips about shareholding and setting up of teams, rewarding staff and advisors with shares. What kind of impact will that have on the financing? So I guess that's an incentives-based question for Susanna.
Yeah, to Betty, wherever you are. Employee incentivization is a really interesting topic. What actually works to incentivize people. I think that the critical question is, what are you incentivizing for? So go back to basics. Is it a short-term incentive that you're looking for, 1 to 3 years, in which case cash, bonuses, shares? If it's a longer-term incentive program, so if you're working towards an IPO or a sale or a round of investment, then it might be something more like an EMI scheme, an enterprise management incentive arrangement, which are more tax efficient. There are lots of, those generally are tax driven, and your company has to meet certain thresholds and criteria. It's absolutely critical that if you are going to set up any sort of share or incentive arrangement, that you do it properly. Don't do that on a shoestring. Hopefully if you're in the realms of thinking about employee incentivization in those terms, you're maybe slightly further along. I'm not an incentives lawyer. We do have an incentives team. But if you want to reap the tax benefits from it, it's really important they're set up properly. Equally, any funders coming in will scrutinise those schemes to make sure that they work. And if they don't work, that's again going to be a big red flag on a DD report, because it potentially means there's lots of backdated tax liabilities that someone's going to have to fork out for. So think about it. And there's lots of publicly available research, which is quite interesting, if that's your thing, about actually what works to incentivize people, is in terms of the bonus culture, cash bonuses. is it better just to pay above average basics and actually just pay people for doing a really good job rather than creating an expectation of cash for actually just doing what you'd expect them to do anyway? So lots of very interesting thought processes to go behind it. But
Right. If
I
you
won't
see
bore
Betty,
you.
tell her, yeah?
Yeah, if anyone sees Betty, pass that on.
So we do have a couple of minutes left before we break for lunch, and I just wondered if anyone had any other questions that they'd like to discuss with the lawyers now. Hands up. Oh, one over there. There we go.
It's not so much a question, it's more about a response back in relation to the marketing question. So one of the things I think is really important when startups obviously are looking to come up with their strategy is often if you get an agency involved on a retained basis too early, you spend a whole lot of money on stuff that you don't actually really need. And I think it's really important to bring in those areas of expertise for small micro consultancy sessions so that in essence you can get your marketing strategy mapped out, you can get your digital strategy mapped out. And so instead of actually turning around and saying, okay, I'm clueless, I don't have a clue what to do, the reality is you will have a good gut feel as to who the customers are that you're looking to reach. And actually spending that time not delegating my abdication, but actually really getting involved and sort of thrashing that out, you'll then hit the roadblocks where you actually need to bring the specialists in. But again, you can just bring people in using sites like Mavin or sort of small micro consultancy sites where you can basically get someone's time for an hour and spend 200 quid on that level of expertise. And then instead of being tied into an ongoing retainer, you've got that really specialist advice which helps you sort of scale at the points that you need.
Yeah, that's an excellent point. I guess the marketing community's been disrupted as much as everybody else, and they're part of the gig economy now. So, yeah, great point. Are there any other questions? Lady in the middle there, in a nice scarf.
Hi, this is an IP question, very simple. If you develop an app, would you recommend to register it, even if it's already, of course, covered by copyright? Or that there are lots of services online that can do it? Or would you just not recommend to register the copyright? In terms of like providing evidence for the future if there is any litigation.
You're talking about owner in terms of when there are different rights that are kind of at play here. So in terms of registration, so copyright does not require registration in the UK. It's an automatic right that extends into a number of territories, but it covers different things. So it might cover your logo and stop someone copying your logo. However, it wouldn't necessarily protect, and in fact, it wouldn't protect the name of your business. And having a trademark registration is an easy way of showing value in your business. And obviously, I work with Sam regularly, and obviously with Lewis and the rest of a kind of broader teams. But having that trademark registration gives you a monopoly right over that name against the goods and services register. So it's quite a strong right. In the UK, just using it will give you some rights, but you're going to have to put together reams of evidence about why you've got goodwill in the brand, why it distinguishes you from others, and it can be very expensive as opposed to just something that people can look for online. And as to whether you should use the online services that are available, so there are a number. I think you were talking about kind of online registration services and things.
Yes, my question was if you have an application, if you're developing an application, an app, so an app will be covered by copyright because it has the data and, a name, whatever. So it will be, usually it's copyrighted already by itself. However, is it reasonable to register it also just as to have the evidence of the date and the name of the developer? And there are some services. So in the United States, there is a service that does it. In the UK, there are several private services that do it, but are they worth using or is it just useless?
So you don't need to register copyright in the UK for it to exist. What you can, there are services where you can record, as you say, the ownership, or you could develop an email address that you send things to yourself. It used to be that people sent things in the post and didn't open them. Now you could potentially send an email, you can date stamp things. It also goes for designs. And that right can be enforced internationally. It might be that, say, for example, if the US is an important market, based on the evidence of the right in the UK, you can actually register in the US. China's somewhere we register copyright in quite a lot for clients as well. But it's certainly not something that's a requirement. You certainly don't have to use those services, but you do need to think about evidencing it. And we do have issues when clients come to us, they haven't kept appropriate records, and they haven't got the agreements that Lewis talked about in place with the people who actually developed it. So firstly, they don't own it. It sits somewhere else, and we sometimes have to contact people 5, 10 years down the line, and that person doesn't exist, or actually perhaps even the company that he worked for doesn't exist, and you have all kinds of issues. So get the commercial agreement in place to ensure you own it, and get, you know, appropriate records in place to kind of evidence who created it and at the appropriate time.
So basically, you don't recommend to your clients to also take extra steps to go and register. It's just emailing yourself your app, or just keeping track, and good documentation is enough.
Yeah, we don't recommend that people register copyright in the UK. No.
Okay, thank you.
There isn't a process.
One more for the sandwich conversation, I think. I think we've probably got time for one or two more. So, Olga. Any more before we pass to Olga? Go on, Olga.
No, it's just that out of all the questions I've sent, it's the most legal question wasn't picked up, and I did want to ask that. If I'm dealing with potential investors who are not UK-based and they're coming sort of from India, very little presence in the UK, how do I go about due diligence? Like, how do I even learn, where do I go with that?
Who wants to deal with that one? Good man, Sam.
That's a good question. I think the answer is that it's probably more difficult than if you're due diligencing someone who's based in the UK. But I think that's only because that working in the UK, you're more familiar with UK systems and UK institutions and how you go about finding information in the UK. So if you were diligencing a UK investor, you'd probably only be looking at publicly available information online, whether that's through Companies House or whether that's just Google searching or however else. So you can use the same approach if someone in India. I have to admit, I'm not au fait with the Indian equivalent of the company registry. I'm sure they do have one. I'm not sure if it's available online, but I think do all the searching that you can online, and then if you're particularly concerned about it, then I think the only thing you can really do to give yourself comfort is to instruct someone locally to help you do that due diligence, whether it's a kind of commercial DD provider or a law firm.
Great, thank you. Are there any more questions before we finish? Great. In which case, thank you very much for attending. Thank you for your attention. Thank you to unBound for asking us to speak. And please join me in thanking our panel who spoke so well today. Thank you.